Good morning, good morning. Happy and merry, not so stupid o'clock. Thank you, Labor Day weekend, for giving me tolerable work hours. To another episode of Spilling Tea, I am your host, Tiffany Daniels. Now, folks, before we get back into the judge's decision in regards to the 2007 incident, a few disclaimers. You're going to find a link to this document in the description, as well as the other pertinent Stop This Shock campaign links, the Autisticahoya Massive Archive. Stevie, if you happen to watch this video, there is tons more of witness testimonies in there, as well as other pertinent information. If you could take a look at those and spread them around, I'd appreciate it, as well as you others. We also have the templates, folks. Templates. We have got a whole bunch of them. That link, you can fill in your name and click on your senator for improper restraint. Let's get it banned, folks. Also, don't forget to stop by ASAN, where those templates come from, by the way. There's two other important ones, including those of us who are stuck on SSI. We're getting a little tired of living below the poverty line and barely being able to make it. So please take a look at that template. There's another one in there as well. Also, please sign the change.org petition to shut the Judge Rotenberg Center down. It's time these assholes were made history. Now, folks, there has been something that has come to my attention as of last night. It looks like there is some scientists who have decided that irradiating the brain of autistic children is okay. This was found by one of my allies on the, oh my goodness, what is it called? PubMed website. I'm not going into that this morning. I need to be able to calm down and either A, not cry, or B, rant with explicitives that would make even a sailor blush. So, just know that that is probably going to be coming tomorrow. Now, before we get started this morning, as always, folks, when we are talking about the JRC, you are going to hear vivid descriptions of and sometimes catch video clips of video surveillance of people with disabilities being tortured and abused. If you have young children present, please use your headphones. And yes, it's 5:27. Yes, it's a somewhat decent hour. But folks, let's face it, it's me, and I have probably still not had enough caffeine. So if I mangle any words or pronunciations horribly, my apologies in advance. So, back to where we stopped yesterday, the JRC's student population. There are approximately 236 students at JRC. Remember, this is about around 2007, so these numbers are not the same as they are at the moment. Just wanted to put that disclaimer in there. 35% of JRC's clients are emotionally disturbed, behaviorally disordered adolescents, while 65% are autistic, developmentally delayed children, and adults. 17% of JRC's school-aged clients are court-approved for the GED. Because court-approved makes it right. Judge, that's not really how it works. I don't know if you realized it yet, but you all are far from infallible. You all have given a free pass to people who have been torturing these kids since 1986. Judges are not infallible. You're not the end-all be-all to decide what is or is against human freaking rights and ethics codes. Medicine is supposed to be about doing no harm. This is far from it. Just saying. Of this, 17%, 99.9% are autistic and developmentally delayed, because that makes it okay, I guess. The executive director of JRC indicated that the school currently has more adults than it has in the past, and that clients are choosing to stay at JRC to finish their education after they have turned 18. Are they? Are they, though? How many of those kids are actually their own guardians? I would actually like to find that out. Are they actually being the ones to decide? Or are you all compelling them to? That would be something I'd be very interested in knowing about. Of all those that stay after age 18, how many of those students are their own guardians and are the ones that are actually making the decisions? Just saying. Okay, so a lot to unpack in this particular paragraph, folks. First of all, the fact that they believe that using the same treatment for people with very different diagnoses is on its head complete logical stupidity. You cannot treat diagnoses with the same sort of treatment. That's not how medicine works. They're completely different diagnoses and need to be treated as such. You can't use a cookie cutter approach on this. Different mental disorders need different treatments. Different neurological conditions need different treatment. Different people with mental health issues need different treatment depending on what those mental health issues happen to be. This is on its head. Complete stupidity. I mean, that right there should immediately disqualify the JRC for having a so called professional opinion on anything, ever. Just saying. You are essentially giving everyone the same treatment whose diagnoses are widely different from one another. It's beyond stupid. I don't understand it. And again, I would be very interested in finding out for all those kids that chose during this time to stay at the JRC after 18, how many of those kids actually made those decisions, and how many of them actually were not their own guardians, and it was the conservator making those decisions for them. Just saying is all. Moving on. Oh, God. I'm really going to try not to rant, but I can't really make any promises. Court approval for treatment programs. Because that makes it right. We've already proven these judges have no idea about the practice of medicine whatsoever, especially in regards to how to use treatment in regards to those with mental health issues, autism, and various disabilities. If they can approve of this general treatment for people with widely different diagnoses, then yeah, they shouldn't be able to pass decisions in regards to the practice of medicine whatsoever. But moving on. The current regulations regarding the court approval process for behavior modification treatment plans resulted in a 1985 lawsuit brought by the parents of JRC students and JRC seeking an injunction to stop the Massachusetts Office for Children from enforcing its decision to take away JRC's license to operate because of JRC's use of Avesersives, which is absolute. The fact that this place wasn't closed down back in 86 is completely mind-blowing. Mind-blowing. This place should have been closed down and condemned a very, very long time ago. Eventually, the parties entered into a settlement agreement in 1986. Under this agreement, substitute judgment hearings must be held for each student JRC is seeking to use Avesersives with. with a court monitor was appointed to visit JRC periodically and report on JRC's treatment and education program to the court. And the Office for Children's Licensing Power was transferred to the Massachusetts Department of Mental Health. JRC then worked with the Department of Mental Health to promulgate new regulations related to Avesersives. Subsequently, in 1988, these licensing powers were transferred again to the Massachusetts Department of Developmental Services. See, this is what I don't understand. So, either the court systems and the Massachusetts Department of Mental Health and their Department of Developmental Services are completely ignorant of what goes on behind the closed doors at the JRC, because they have those monitors go through. Willfully ignorant, I might add, if they're constantly visiting the grounds, or they are 100% complicit in the torture that is going on there. So I wonder which one is it. Are they complicit or are they ignorant? And if they are ignorant, why? After everything that has come out, have they not done their own thorough investigation of this place? Why have us advocates had to go to our federal government, and when that didn't work, had to go to the UN and then back to the federal government? I'm just saying. Why this idea that adversives are a good thing to use, I will never understand. But they're hurting themselves, Tiffany. They're hurting others. Not all of them are. A lot of them are receiving shocks for non-compliance with nonsensical orders. Okay? There is no productive value to being told to fold, unfold, and fold freaking same napkins over and over again. And I'm not allowed to question that or shock. How dare I question authority? Just what are you trying to do there? Moving on. Today, under 115 CMR 5.14, a Massachusetts probate court judge must approve of the use of adversive interventions for each student before they may be used. But remember when Jennifer Masumba said just how these judges are manipulated? They bring these kids into the courtroom by force in multiple restraints. And let's face it, on its head, neurotypicals, and this is not an insult to y'all who watch this channel, by the way. What would you think as a judge if someone's being brought in complete heavy restraints? And then you had someone who's supposed to be a professional telling you, well, they're dangerous. They're engaging in dangerous behaviors. What are you going to think? Are you going to sign off on something like this? Maybe, maybe not. But still, there is a high level of manipulation that the JRC uses, along with blending in manipulation and lies to get judges to sign off on this shit. And people don't read any further into it than what they see. Which, with this case, you really need to. The probate court judge first assigns the student independent counsel to evaluate the student and his and her treatment needs. This has been proven to be bullshit, by the way. Remember Jennifer Masumba's story and Anna's. They did not even have access to lawyers. This is a bunch of garbage. A substitute judgment hearing is then held to review the evidence of the student's diagnosis, treatment history, and treatment options in order for the judge to determine whether adversive interventions are appropriate. Now, remember how these kids are previously treated in the institutions. I point again to Jennifer Masumba's story, Andre McCollum's story, and Anna's story. Prior to this hearing, JRC must submit a treatment plan recommended by the student's experienced and trained treating clinician containing behaviors to be treated the student's parent guardian's written consent, and the evaluation by a physician indicating whether any medical reasons exist that prohibit the use of aversive treatment. So there's a whole line of people who are complicit. The guardians, the on-site clinician, the on-site doctors. It's a one-stop torture shop, folks. These people get all their local doctors and psychiatrists to sign off on this shit. They bamboozle the guardians or the parents into agreeing, thinking that's what they need. God. The JRC facilities meeting of a human rights committee and a peer review committee who must also approve the treatment plan prior to the plan being submitted to the probate court. Any human rights committee that can sign off on this shit is not for human rights at all and should be disbanded and its people put in jail. I'm going to say it. And with those final thoughts, folks, we're going to go ahead and sign off for this morning. Now, as always, folks, we don't get very many views on this channel, especially on this very important subject. The few that we do tend to get removed from time to time. So, folks, please don't forget to hit that like button. Hit subscribe. Don't forget to hit the comments. Feed that algorithm. I do appreciate your time this morning. And as always, we here at Spilling Tea hope you have a good one. Bye-bye.